Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Goeringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland, and welcome back to another episode. Today, we're going to talk about an issue that can develop in estate planning and is sometimes a hard issue to settle, with the goal being, after you listen to this, you should just take care of this issue automatically and just not let it develop in the farm itself. The idea is, what is sweat equity? And I always go back to this idea with sweat equity. If any of you have seen Monty Python and the Search for the Holy Grail, the idea is at one point, the Lord comes out and looks at his son and says, "Lad, all this one day will be yours." Well, that works in England. You can say that potentially as long as you're in the royalty and, you have that ability to tell the firstborn child that will be theirs. In the US, it doesn't work that way. We have to develop an estate plan. We have to do a lot. If no estate plans develop, sweat equity can develop within the operation. And it becomes, how do we put a value on this? No, it's really hard to put a value on this. So let's talk a little bit about the work and the fact sheet this is associated with, and all the co-authors are listed in the show notes. You can go in and take a look at it yourself and read it at your own leisure and, figure out what you think about it. But determining the value of sweat equity can be a challenge and controversial for many farm families. Sweat equity can arise as an issue when an on-farm heir receives payment at below market rate, and the farm business grows in size due to an on-farm heir's below market rate labors. There's no agreement, there's nothing ever written that says at some point the on-farm heir will get the farm in return for all this work. Land in the farm may also appreciate in value due to the work of the on-farm heir. Since farmland is typically the bulk of the farm assets, dividing the assets equally among on-farm and off-farm heirs means on-farm heirs could potentially get a portion of the farmland too small to generate a livable farming income. At the same time, off-farm heirs may receive farm assets which have increased in value due to the work of the on-farm heir. Only 30% of farm transitions past the founding generation, 12% transition past the first generation, and only 3% transition past the second generation. And handling sweat equity issues when bringing in the on-farm successor can limit issues down the road where an on-farm heir feels slighted. Properly ensuring the success of a farm for future generations is a challenging task, but steps can be taken ahead of time to avoid problems. It is important to note here that the best solution for handling sweat equity is to agree early on to pay the on-farm heir at a market rate. Handling sweat equity early on may necessitate the on-farm heir also work off the farm for additional income if the farm cannot support an additional full-time person. It is important to discuss the farm succession plan and limit the possibility of sweat equity claims at an early stage of farm expansion. And I'll provide some more details to where you can find information on that, not only in the fact sheet that's linked here, but I'll try to provide additional resources as well. One of the first problems arising from sweat equity is the lack of communication between farm owners and the individuals working on the farm, i.e. the on-farm heir. Both parties need to set clear expectation. The farmer should know how much the on-farm heir expects for a certain time, and the on-farm heir should know how much labor he or she is expected to give. Without a clear set of expectations and guidelines, there is a lack of enforceability. The idea of sweat equity, when not properly outlined, can hide the fact that a farm is not as profitable as needed to support the on-farm heir. Thus, setting clear guidelines and expectations for both the on-farm heir and farmer will, well before the transition process occurs, is essential. Farm owners often find themselves between the future farm success and the fair treatment of the farms to heirs and children during the transitioning planning stage. There is an important distinction in the transitioning process between deeming equitable and equal behaviors. For example, if John owns 100 acres of land and has two sons, giving each 50 acres upon his death is fair. However, if one son has worked on the farm for 30 years while the other son has distanced himself from the farm, each son receiving 50 acres is equal but not necessarily equitable. A farmer may compensate the son who worked on the farm for 30 years more than the other son. So the question often becomes, how do owners set themselves up for a smooth transitioning process? Most owners would agree that there are two primary goals of a transitioning plan. One, securing the farm's financial viability, and two, transitioning the farm in such a way to make everyone happy. It is important to remember in the transition process that parents treating all heirs fairly does not necessarily mean equally. We just discussed this. As one farm transition specialist has stated, treating unequally equally may be the most unfair thing you can do. An example to illustrate this and how a farm can struggle with determining the value of sweat equity without a transitioning plan in place, George and Louise Jefferson own farmland in Maryland and have 3 adult children. One child, Michael, returned to the farm to work in 1999 and has continued to work on the farm. Since then, the other 2 children have left the farm. Michael's work has increased the value of the farmland. Equally dividing the farmland might be considered unfair due to Michael's contributions. Looking deeper at the example, the value of the farm has increased from $800,000 to $1.5 million since Michael's return. George and Louise agree that the $800,000 value of the farm before Michael returned should be equally split among their 3 children. The $700,000 increase in the value since Michael's return is due to his work and not that of the other 2 children. The Jeffersons determined it would be not fair to simply divide the increase in farm value since Michael's returned by 3. They feel he deserves a larger share for the labor he put into the farm. If the Jeffersons had compensated Michael for his labors at the start, this would have made this issue easier to handle if we think about it. While Michael was never promised reimbursement for sweat equity, George, Louise, and Michael acknowledged that decisions which increased the value of the farm, such as renting and purchasing more farmland, were possible because of Michael's sweat equity investment. The Jeffersons also realized that simply dividing the farm into 3 may not provide enough land to be viable, and that they have to recognize Michael's contribution to the farm's success. George and Louise decide they will divide the value of the farm before Michael's return equally among their children, with each child getting $800,000 divided by 3, or $266,667. The increase in value after Michael's return, that $700,000, will be split 50% to Michael and the other 50% deemed to be the parents' contribution. Since Michael's return, the parents' contribution would be equally split among all 3 children, or $516,667 to Michael and $166,667 to the other 2 children. In the end, Michael would receive $783,334, and the other 2 children would receive $383,334 each. Many issues can be worked out if there are clear expectations set ahead of time. That's the one thing I hope you get from this discussion today, is you really need to do this early on. Engaging lawyers, accountants, family members, and business consultants in advance can alleviate many farm transitioning problems. Beginning the transition planning process early developing agreements on how to compensate on-farm heirs and how the business will be transitioned to the next generation will provide a smoother transition than trying to handle the sweat equity issue later on. It will also reduce hard feelings down the road when the on-farm heir may feel slighted down the road. These are things we need to think about in this process, and many things that some of you may not be considering in the operation. Again, if you have any questions, please shoot me an email at lgoering@umd.edu, or you can tweet me at aglawpaul. Thank you again for listening, and enjoy the rest of your day.